The voice on the recording was my daughter's. I'd heard that voice read bedtime stories, sing off-key in the car, crack up laughing at things that weren't even funny. I knew every note of it. And now it was saying, if we do this right, he won't make it to the hospital. The cold will handle the rest. And then everything's ours. The courtroom went completely still. Even my daughter's lawyers stopped writing. I sat in the front row and watched her face go the color of old snow. Let me go back a little. Not to the beginning. There's no clean beginning to a story like this, but to the part where things started to feel wrong. My name is Walter Drummond. I'm 71 years old. I spent 32 years as a Crown attorney in Halifax, Nova Scotia. I've prosecuted fraud, manslaughter, financial crimes that took years to unravel. I've sat across tables from people who looked perfectly ordinary and knew they had done terrible things. I learned a long time ago that guilt doesn't announce itself. It just waits, very quietly, for the right moment to be found. I retired in 2019. My wife Carolyn passed in 2021, pancreatic cancer, quick and brutal, the way it always is. After she was gone, I sold the house we'd raised our family in and moved to a smaller place in Lunenburg, about an hour from Halifax on the South Shore. Old town, fishing heritage, the kind of place tourists photograph in summer and locals actually live in year-round. I had my pension. I had the savings Carolyn and I had built over 40 years. I had the proceeds from the Halifax house. Altogether, it was a comfortable life. Not extravagant, comfortable. The kind of comfortable that takes a lifetime to build. My daughter, I'll call her that, because she's earned no right to her name in this story, moved back to Nova Scotia in 2022 with her husband. I'll call him what I eventually came to understand him to be, an operator. I don't mean that as slang. I mean it clinically. He operated on people. He found the angle, the weakness, the point of entry. My daughter had always been smart and a little reckless. She had her mother's eyes and her grandmother's stubbornness, and, it turned out, her husband's ambitions. They moved in with me that fall, just temporarily, they said, just while they sorted out finances, found their footing, got back on their feet. My son-in-law had burned through a business venture in Calgary, something involving logistics and a contract that fell through, or so he said, and they needed a reset. I was the reset. I told myself it was fine, that this was what family did, that Carolyn would have wanted me to help. Carolyn had always been the one who read people clearly. I missed that most of all. The first few months were ordinary enough. They cooked dinners, drove me to appointments, watched hockey with me on Tuesday nights. My son-in-law was charming in the way that some people are charming, as a deliberate act, not a natural one. He laughed at the right moments. He asked questions that made you feel interesting. He had this particular way of listening that made you feel interesting. He had this particular way of listening that made you feel like what you were saying mattered enormously. I noticed it. I filed it away. Then small things started to shift. My daughter began asking questions about the Lunenburg house. Casual questions, framed as curiosity. How much do you think it's worth now, with the market the way it is? Have you thought about downsizing? Wouldn't it be something to see it go to family someday? I answered honestly the way I always did. I told her I had a will, that she and her brother in Vancouver knew the basic shape of it, and that nothing needed discussing right now. She dropped it, and then her husband picked it up. He was more subtle. He talked about it sideways. Did I know that probate in Nova Scotia could eat a significant percentage of an estate? Had I looked at Intervivo's trusts? His brother-in-law had done one, saved the family $40,000. He could connect me with someone. He knew a guy. I recognized the pattern. I'd watched prosecutors and defense lawyers use the same one for 30 years. You circle the thing you want. You make the other person feel like coming to it was their own idea. I started writing things down. I have a habit from my prosecutorial years of keeping notes, not for any particular purpose, just as a way of thinking. I began keeping a separate notebook about this, dates, conversations, exact quotes where I could remember them, It felt excessive. It felt like I was being unkind to my own daughter. But I kept going because I'd learned that the moment you stop documenting is usually the moment you most needed to have been. Around Christmas that year, I made 2 phone calls. The first was to my solicitor, a woman named Patricia who'd handled my affairs for 15 years. I told her I wanted to review my will and make some adjustments. I also wanted to discuss my house, specifically whether there was a mechanism by which I could make clear that any assets I held were not to be transferred, signed over, or managed by any family member without my independent legal counsel present. She thought I was being overly cautious. I told her I had 32 years of prosecutorial experience and an instinct I'd stopped second-guessing a long time ago. The second call was to my son in Vancouver. I didn't alarm him. I told him I was doing some estate planning, wanted him to be aware, and asked if he could come out for a visit in the spring. He said of course. He asked if everything was okay. I told him things were fine, just getting organized. He knew me well enough to hear what I wasn't saying, but he didn't push. I told him I'd explain more when he arrived. After Christmas, the conversations became more direct. My son-in-law brought up the house again, this time with a more concrete angle. He'd done some research, he said this casually, as if he hadn't clearly been planning it, and apparently if I added my daughter to the title now, as a joint tenant, the property would pass outside of probate entirely upon my death. Simpler for everyone, cleaner, more efficient. I said I'd think about it. What I actually did was call Patricia again the next morning and ask her to draw up a separate document, nothing formal, just a clearly dated statutory declaration stating that I had no intention of adding anyone to the title of my property, that I was of sound mind and acting without duress, and that any future transfer documents should be regarded with extreme scrutiny. She drew it up. I signed it. I had it witnessed by 2 people completely outside my family circle, my neighbor Gwen, who's been on my street for 12 years, and my family doctor. February came. I had a cold that turned into bronchitis, which kept me in bed for the better part of 2 weeks. During that time, my daughter was genuinely helpful, brought me soup, picked up my prescriptions from the pharmacy in town, made sure I was taking my medications on schedule. I remember lying in bed thinking I was being paranoid, that I had constructed a conspiracy out of ordinary greed, ordinary ambition, the ordinary tensions that happen when adult children expect more than they're given. Then I found the folder. My son-in-law worked from home, mostly from the kitchen table. He kept his papers in a leather portfolio that he usually carried with him. One afternoon, while I was resting on the couch with the flu slowly retreating, he left it on the counter when he stepped outside to take a phone call. I didn't go through it deliberately. I reached for the television remote on the counter beside it, and it slipped, and papers fell out. The first thing I noticed was my name on a form I didn't recognize. Then I looked more carefully. It was a draft application for personal guardianship. In Nova Scotia, under the Adult Capacity and Decision-Making Act, someone can apply to become the legal guardian of an adult deemed incapable of managing their own affairs. The form had my name as the subject, my daughter's name as the proposed guardian. It had been filled out with careful handwriting and referenced a physician's assessment, an assessment I had never given consent for. I put the papers back exactly as I'd found them. I went to my bedroom. I sat on the edge of the bed for a long time. Then I did what I had trained myself to do 30 years ago when a case revealed something unexpected. I did not react. I planned. Over the next 3 weeks, I moved carefully. I contacted Patricia and told her everything. She immediately advised me to document everything I could without alerting them. I began keeping not just written notes but recordings. Nova Scotia is a one-party consent province, which meant I could legally record conversations I was part of without notifying the other parties. I bought a small voice recorder, the kind you'd use for dictation, and kept it in my shirt pocket. I also saw my family doctor and requested a full cognitive assessment. I wanted a clinical record, dated and signed, establishing that my mental capacity was intact. My doctor looked at me a little oddly. I was clearly sharp, clearly oriented, but she obliged. The assessment came back with no concerns flagged. I had Patricia add it to my file. My son came out from Vancouver in April. I told him everything then, the guardianship form, the title conversation, the pattern I'd been watching for months. He was furious in the quiet way he gets furious, which is worse than yelling. He wanted to confront them immediately. I asked him to wait. I had something specific in mind. I had an old colleague, retired RCMP investigator. We'd worked overlapping cases for years, and I reached out to him to ask about surveillance options for my own home. He walked me through it. I installed 2 cameras in common areas, one in the kitchen living space, one near the front door, entirely legal on my own property. I didn't tell my daughter or son-in-law. Over the following weeks, the cameras recorded several things. Most of it was unremarkable. But there were 2 conversations that were not. The first was my daughter and son-in-law discussing the guardianship application timeline, specifically whether they could move forward with a physician assessment without my knowledge by framing it as a routine wellness check. My son-in-law said he had a contact, a general practitioner who'd helped a friend of his with a similar situation in Alberta. My daughter hesitated. Then she said, "What if he's already done something with the will?" My son-in-law said, "Doesn't matter. If we get guardianship, he can't do anything without our sign-off anyway." The second conversation happened on a Thursday evening in early May, after I'd mentioned offhandedly at dinner that I was thinking of driving up to Cape Breton the following weekend to visit an old friend. The weather had been variable, warm days, but cold nights, and the tail end of a frost warning for the interior of the province. What they said, when they thought I was asleep, was this. My son-in-law said, "If he drives up alone in that weather and something happens on the Trans-Canada, there's not much anyone can do about that." My daughter was quiet for a moment. Then she said, "He could get confused. He gets confused sometimes." "He doesn't, actually," my son-in-law said. "But that's what the assessment was going to establish. If something happened up there," my daughter said slowly, "an accident, the cold, the estate would settle much faster without a contested will. No capacity questions, no litigation." She didn't say anything for a while. Then, "And my brother? He's in Vancouver. He'd find out after." I lay in my bedroom and listened to the playback of that recording 4 times. Then I called my son. Then I called my Patricia. Then I called my old RCMP colleague. Then I cancelled the Cape Breton trip. The case built quietly after that, the way good cases always do. Patricia connected me with a criminal lawyer in Halifax named Roger, who had 30 years in fraud and elder abuse litigation. He reviewed everything: the recordings, the guardianship application draft, the statutory declaration I'd signed back in January, the cognitive assessment, the title conversation notes. He was thorough and unhurried, and he said after 2 hours of review, "Walter, you've done half my job for me." We went to the RCMP in June. The investigator assigned to the file, a younger woman, very precise, very methodical, reviewed the recordings and the documentation and determined there was enough to proceed on multiple fronts: fraud, attempted obtaining of property by false pretenses, and, based on the Cape Breton conversation, conspiracy to commit criminal negligence causing bodily harm. The arrests happened on a Tuesday morning, 4 months after I'd found the guardianship papers. My daughter called me from the police station. She was crying. She kept saying she didn't understand, that there had been a mistake, that things had been taken out of context. I told her I loved her. I told her I was sorry it had come to this. I told her I had evidence she needed to hear before she said anything else without a lawyer present. She stopped crying. She said, "You recorded us." I said, "I did." She hung up. The preliminary hearing took place in Halifax Provincial Court in November. My son flew in from Vancouver and sat beside me. My son-in-law's lawyer, a man who specialized in the kind of aggressive procedural motions that delay proceedings, argued that the recordings were inadmissible. Roger dismantled that argument in about 12 minutes. One-party consent. My own home. My voice on every recording. The guardianship application draft was entered into evidence. A handwriting analyst confirmed it was in my son-in-law's handwriting. The physician he'd referenced as a contact was interviewed. He denied any knowledge of a planned assessment, which either meant he was telling the truth or meant he'd decided very quickly to distance himself. My cognitive assessment was presented. My lawyer made a point of having my physician read the summary aloud. No evidence of cognitive impairment. Patient demonstrates above-average recall and executive function. My daughter's lawyer tried to reframe the Cape Breton conversation as dark humor, a couple venting about a difficult family situation, words taken out of context. Roger played the recording in full, the pauses, the careful phrasing, the explicit discussion of the estate. The judge asked the lawyer to clarify what context would make the phrase, "the estate would settle much faster," an expression of affection. The lawyer had no answer. My son-in-law pleaded guilty in January to fraud over $5,000 and conspiracy to commit criminal negligence. He received 4 years in a federal penitentiary and was barred from acting as a financial or legal representative for any person for life. My daughter pleaded not guilty and went to trial. It was, in many ways, harder to watch than the preliminary hearing. Not because the outcome was uncertain, the evidence was what it was, but because I sat in that courtroom and watched a person I had raised, had loved without reservation for 36 years, try to explain away things that could not be explained away. Her lawyer made much of the stress they'd been under, the failed business in Calgary, the financial pressure, the desperation that can make people do things they would never otherwise consider. I understood that argument. I had made versions of it myself, defending context and circumstance in prosecutions that were less clear-cut than this one. But context doesn't erase the recording. Context doesn't explain the guardianship application filled out in advance, in careful handwriting, referencing a physician my son-in-law had apparently already approached. The verdict came back guilty on 2 counts, fraud over $5,000 and counseling to commit an offense, specifically the Cape Breton conversation, which the court found constituted counseling criminal negligence rather than mere venting. She received 3 years, with the possibility of parole at 18 months. The Crown had asked for 4. Roger told me afterward that the judge had weighted the fact that she'd shown some hesitation in the recordings, that she hadn't been the one to initiate the specific suggestion. I've thought about that distinction a lot since then. Whether it matters, whether the hesitation means something, I don't know. I'm still not sure. After sentencing, before she was taken out, my daughter looked at me from across the courtroom. It wasn't the look I'd been bracing for. Not anger, not hatred. It was something I hadn't expected. It looked like she was trying to find the version of me she'd grown up with, the one who made Saturday morning pancakes and drove her to skating at 6 in the morning and sat up late to help her study for the bar admission exams she eventually chose not to take. She was looking for that person, and I could see the moment she understood that person was still there, that he'd been there the whole time. That was the hardest part of all of it. The house in Lunenburg is still mine. I had no intention of selling it. The property is worth somewhere in the range of $750,000 now. The South Shore market has done what real estate everywhere in Canada seems intent on doing. But I'm not interested in numbers. I'm interested in the view of Mahone Bay from my back window. I'm interested in the way the light comes off the water in October. My son visits more now. He flies in from Vancouver every 2 months or so, stays a week. He doesn't push me to talk about it. He brings his 2 kids and they run around the house the way kids should. And we eat too much and stay up too late. And it's ordinary in a way that feels like a gift. I updated my will. Patricia drafted it carefully, with every possible protection built in. It goes into a trust upon my death, a portion to my son directly, a portion to 3 organizations, a legal aid clinic in Halifax that assists seniors with estate planning and capacity disputes, a domestic abuse shelter in Dartmouth that supports older women leaving controlling relationships, and a scholarship fund at Dalhousie Law School for students pursuing elder law. My son knows this. He said, "Dad, that's exactly right." That was all either of us needed to say. I still walk every morning. Down to the waterfront, along the docks, back up through the old town. Lunenburg is a UNESCO World Heritage Site. Did you know that? The whole downtown. Wooden buildings painted in colors that shouldn't work together, but somehow do. History that goes back 3 centuries, longer if you count the Mi'kmaq presence that preceded European settlement. I walk through it every morning and remind myself that this is what I stayed for. This ordinary, irreplaceable, specific life. There are days when I think about my daughter and feel the kind of grief that doesn't have a clean shape to it. Not anger, not loss exactly, just a gray, persistent ache. She was the child who used to fall asleep in the car, and I'd carry her inside so she wouldn't wake up. She was the one who called me every Sunday through law school. even when she had nothing particular to say. I don't know what happened to that person. I suspect my son-in-law had something to do with it, and I suspect she also had something to do with it herself, and I suspect that if I assigned exact percentages, I'd still end up with the same result regardless. What I know is this: I gave them every opportunity to make different choices, every conversation, every deflection. Every time I said, "I'll think about it," and watch them recalibrate. Those were chances to stop, to recognize what they were becoming. They didn't take them. I've prosecuted enough cases to know that the people who are most surprised by consequences are almost always the people most convinced they had accounted for everything. They plan for the outcome they want. They don't plan for the one where the retired Crown attorney they're living with has spent 32 years watching people make exactly the same mistake. Paranoia, my daughter's lawyer called it at one point. That I had manufactured a threat. That I had manufactured a threat. That I had seen conspiracy in ordinary family friction. My old RCMP colleague, when I told him that, laughed for a long time. Then he said, "Paranoia's just pattern recognition without enough evidence yet." I think about that on my morning walk sometimes, about the difference between the two, about how thin that line is, and how you know which side you're on. Mostly I just walk, the harbor in the morning, the old painted buildings, the cold, clean air off the Atlantic, my coffee going cold in my hand while I stand at the dock and watch the water. I'm 71 years old, and I have a clear conscience and time that belongs entirely to me. That's more than enough. I still think about the moment she looked at me across that courtroom and searched for the father she remembered. Not the retired Crown attorney with a recorder in his shirt pocket. The one who stayed up late to help her study, who drove her to skating before sunrise, who never once thought he would need to protect himself from her. I found the guardianship papers by accident. That's the part people don't expect when I tell this story. I wasn't surveilling them. I wasn't suspicious that afternoon. I reached for a television remote and something fell, and what I saw on the floor changed everything. That's how it usually goes. Not a dramatic revelation. Just a piece of paper in the wrong place at the wrong time. What I'd come to believe, after sitting with all of it for the better part of a year, is that what happened had very little to do with money in the end. Money was the object, but what made it possible, what allowed my daughter and her husband to get as far as they did, was a failure of something more basic than greed. It was a failure of conscience, a slow erosion of the understanding that other people are real, that they feel, that they remember, that they deserve to be treated as more than an obstacle between you and what you want. My son-in-law had that failure built into him from the start, I think. My daughter chose it, gradually, in small steps that probably felt reasonable each time she took them. I spent 32 years watching that process. It's never dramatic. It's incremental. A small compromise, then a slightly larger one, then a decision that would have been unthinkable 5 years earlier but feels, by then, like just the next step. That's what the recording showed, if you listened carefully. Not two calculating criminals. Two people who had talked themselves, one conversation at a time, into something monstrous. What stopped them was not luck. I want to be clear about that. I documented carefully because I had trained myself to document. I did not panic because I had spent decades learning not to. I consulted the right people because I had spent a career building relationships with people who knew what I didn't. Preparation is not paranoia. It is a discipline. It is what you build over a lifetime of paying attention, and it is available to anyone willing to do the work. I think about what I would tell someone facing something similar, not a legal strategy. Everyone's situation is different, and I had advantages most people don't. But this: trust what you observe. Write it down. Do not let someone else's comfort with a situation override your own careful reading of it. There is a version of kindness that is actually just avoidance, and I came close to practicing it for too long. The recorder in my pocket, the call to Patricia in January, the cognitive assessment I asked my doctor to run. Those were not acts of hostility. They were acts of self-respect. They were me deciding that my life, my home, my remaining years were worth defending with the same rigor I had once applied to defending strangers in courtrooms. My daughter is serving her sentence. I don't know who she'll be when she comes out. I know who I hope she'll be. Whether that person exists is something she'll have to decide for herself, one small choice at a time. The same way she chose the person who ended up across from me in that courtroom. I walk every morning. The harbor. The old painted buildings. The Atlantic cold. I carry my coffee and I think about nothing complicated. It turns out that's its own kind of work, too. Learning to let a morning be just a morning. I'm getting better at it.